Welcome to the Orientation podcast series from the University of Ottawa Faculty of Law Common Law section. My name is Professor Kyle Kirkup, and I'm the English Common Law Orientation Coordinator and co-host of this podcast. You will also hear on this podcast channel co-host and French Common Law Orientation Coordinator, Professor Anne Lévesque. We are both very excited to welcome you to the University of Ottawa Faculty of Law Common Law section. Each week, we will release episodes with professors at the Faculty of Law. Our goal is to introduce you to our law school community and to get you excited about the possibilities of your legal education. We will also have conversations on this podcast in both English and French. You can subscribe to our podcast on Apple Podcast, Spotify, Google Podcasts, YouTube with closed captioning, or wherever you are listening to this episode right now. Professor Vivek Krishnamurthy is the Samuelson Glushko Professor of Law and is the director of the Samuelson Glushko Canadian Internet Policy and Public Interest Clinic based at the University of Ottawa. Professor Krishnamurthy was a Rhodes Scholar and following his graduation from Yale Law School, clerked for the Honourable Maurice Fish of the Supreme Court of Canada. Professor Krishnamurthy's scholarship focuses on the regulatory and human rights dimensions of emerging technologies. Previously the assistant director of Harvard Law School's Cyber Law Clinic, he brings a depth of knowledge on the legal and human rights aspects of new technologies. Professor Krishnamurthy, welcome to the podcast.
Thank you so much, Professor Kirkup. It's great to be here.
So can you tell us a little bit about your research?
Yeah, so in a nutshell, my research focuses on the human rights impacts of new technologies. So in terms of human rights, there are a lot of different rights which are guaranteed under both international human rights law and Canadian law in the Charter of Rights and our Human Rights Code. So I look at privacy, the right to free expression, equality, you name it, so the full spectrum of rights. And I look at how technologies ranging from social media platforms and their particular features to implementations of AI in the healthcare sector or the financial sector impact those protected human rights. And that is a question that cannot be generally answered in a broad fashion. It really is specific to the technology and the model of deployment, right? And something else I'm interested in, and this sort of goes back to when I was in law practice, is the responsibility of businesses to respect human rights. So under law, governments have the duty to protect rights, but there's this growing recognition that businesses should operate in a manner consistent with human rights. So a lot of what I think about is how should the Facebooks, Twitters, and Googles of the world incorporate respect for human rights in the way that they operate and in the products and services that they offer and design.
So besides our phones, our smartwatches, and our computers, it sounds as though there are a lot of different devices and technologies that potentially gather data on people. Can you just walk us through what that looks like?
Sure. The way I like to think of it is that we live in a world of pervasive data gathering. So something that's really happened in the last 20 years is that there are small networked sensors all over us, right? And this started with closed circuit TV in public places, like security cameras, right? Which could track your movements in public places. For those of you who live in Ontario and drive on the 407, there's electronic tolling that started to track your movements. But it goes well beyond that now. So if you think about it, your car, I have a GM car, and there's a little button on it that says OnStar, right? Which is supposed to be this great roadside assistance service, which it is. But it's also collecting location data about you and potentially ping that back to GM. When we think about our phones, they are, I think at the center of the data collection universe in a few different ways, right? So there's location data being collected about you, right, from your movements. Everything you do on your phone or on an app is being collected by someone. But there's also a lot of passive data collection. And this is actually very important in the COVID-19 context, right? So people have talked a lot about contact tracing. And all of your gadgets, when you're walking around in the world, emit electronic signals, Bluetooth signals, Wi-Fi signals. They're kind of pinging around in the environment. And if you're listening, you can be collecting this data, right? So location, you walk through a shopping mall. Back when we could do that, stores could collect digital signatures of who's walking by. Um, but it goes well beyond just like the devices, right? I think another side of it is that everything we do online is leaving behind a cookie crumb trail of data, right? So when you're surfing the net, your movements are being tracked almost certainly by Facebook or Google when you're on any large site, right? Your ISPs know what you're doing, right? Your internet service providers like Rogers or Bell. And another sort of aspect of this is what's happening is that data that's collected about you in the offline world, right? So your credit history, your air miles account that sort of shows what you're doing at the store, that stuff is getting correlated with your online data to build a really sophisticated profile of who you are and what your interests are, right?
Slightly terrifying. So who has this data then? You maybe quickly click I agree, whatever that means, and suddenly you've agreed to share data. Who has it, and what are they doing with it, and why is it valuable?
So a great law school answer, and as a lawyer, to any question you're asked is it depends. So I'm going to say it depends. So it depends on the kind of information it is, right? Different players in this data ecosystem can get different data in different ways at different times. So let's start with something simple. Um, you are in front of your house and you are on Facebook, right? You are doing something on Facebook, right? So what kinds of information are being collected about you? Well, if you're connecting to Wi-Fi at your house or at your neighbor's house, any Wi-Fi network you connect to knows that you're connecting to that network, right? So that's one, individuals can have data about you, right? Um, when you're on a platform like Facebook, obviously Facebook has information about you, right? But so too do the apps that you might use through Facebook. So you might authenticate to a site like Eventbrite through Facebook, or you might install some kind of Facebook plugin like a quiz, about what kind of dog are you, right? When you do that, that's sharing data out with Facebook, from Facebook to these app providers. Then there are the conduits, right? So again, the internet service providers are going to collect certain amounts of data about these transactions, right, of different forms. So they're going to have it to a certain extent. There are questions about the operating system manufacturers like the Apples and the Googles and the Microsofts of this world who may get diagnostic data about your device, right, when you click the I agree thing. That reveals a certain amount of information about you. So there's a whole bunch of, let's call it corporate players in the stack that have information about you based on your interactions. And then at the far end, well, the government can get access to this in different ways, pursuant to different legal authorities. Hackers and cyber criminals can also get this information about you through unlawful means, right? So that's sort of the ecosystem of players. But I think one of the things that people don't often realize is that there is this complex ecosystem and that data is moving all over the place, right? So a large platform like Google collects all kinds of data about you, but also shares it out about you to different players in that ecosystem in different ways, subject to different agreements.
So you're saying then that when I Google houses for sale in Ottawa, and then a week later, my Instagram page is showing me sponsored posts from real estate agents, that perhaps might not be accidental?
Not at all accidental, right?
Okay.
I mean, what could be happening? There could be one of two things happening there, right? One is that when you're Googling stuff, Google has some kind of unique identifier about you. So even if you're not logged into Google when you're searching, right? Google is able to track what device you are searching from to a certain extent. And then it is possible that when you're on Instagram, Instagram either has a tie to the Google advertising network that knows that you ran the search, or Instagram might be reading information on your device, a cookie stored by Google that reveals your search history, right? And that's how this really creepy tracking across websites occurs, right? Fundamentally.
So it sounds like this data then could be very valuable to a variety of different entities, whether, it's valuable for monetary purposes or for other purposes. So what are some of the ways that this data might be valuable?
So there's this really influential book by a professor named Shoshana Zuboff at the Harvard Business School called The Age of Surveillance Capitalism. And the argument in her book is that the business model of the modern internet, right, basically rests on the following, which is that consumers pay $0 to access fabulous services like Gmail and Twitter and Instagram, right? So there's no charge at the point of sale, right? You don't pay a subscription like you would for Netflix, but you pay with your data. And that data is valuable and increasingly valuable at a commercial level, because what's happening is that advertisers and others can gain increasingly useful insights about you from that data, right? And this brings us into the world of what's called big data or predictive analytics or AI, artificial intelligence, which is thrown around as a buzzword, huge buzzword. Um, but basically what's happening is that those that have these vast stores of data about you can use it to build profiles, right? Profiles that say, what kind of person are you? What kinds of stuff are you interested in? Therefore, what kinds of ads should we serve to you? Now, that sounds innocuous enough in a purely commercial context. Like if you are a connoisseur of 1960s Japanese running shoes, I picked that example at random for no reason at all. Uh, and like this is your thing, you collect them or you love them, and you want to find the best deals on these shoes. There's some consumer utility function in having precisely targeted advertising, right? But what we're finding is that, of course, the advertising gets misused, but there's also many other uses of the data that raise questions about fairness and equity, right? So what happens if the insights about you that are generated through this vast data collection enterprise are used against you in some way? What if they're used to discriminate against you in the purchase of insurance or in the provision of healthcare, or frankly, price discrimination? There are examples that have been shown where people with Macs get charged more on certain websites than people with PCs on the theory that people with Macs have more money. So those are some of the bad uses that can be made. And, we can talk all about the bad uses, right? So it's valuable in a commercial sense, but it's also valuable to anyone who wants to know something about us for any reason, right? And this brings us into the realm of governments wanting to track what people are doing for various reasons, both legitimate and illegitimate. And it also sort of opens up the really dark specter around misinformation, disinformation, and other kinds of information operations conducted by various actors for various motives, right? Which is all built on the same basic business model, right? We have the system that allows for the collection of a lot of information about you, that reveals a lot about you, that can be used for all kinds of purposes. And we've seen that being weaponized against us in a number of contexts.
So let's then break that down a little bit more. So what implications then do you see for the use of this type of data in the criminal legal system?
So what's really hard about this use of data in criminal justice is that our criminal law is not really set up to deal with this, right? So in kind of the common law legal tradition, right, the way we think about police activity and what the state can and can't do is, okay, do you have some kind of reasonable expectation of privacy, right? if you have a reasonable expectation of privacy and the government wants to intrude and search you, they need to get a warrant. Otherwise, it's unreasonable. So this is Section 8 of the Charter. We see it in a lot of constitutional and quasi-constitutional provisions around the world, like this idea that there's a certain amount of stuff that the police can do, beyond which, if they're going to do it, they need to go and ask a judge for permission because it's very intrusive, or there's some exception, right? You are chasing an armed criminal into a house. And in order to complete the chase, you break into the house without a warrant, right? So there's some justification. Okay, so we have this idea about here's a search, right? There's this moment where click, Section 8 starts to apply. The problem with what we have going on in society now is that there is all of this government activity that is in a criminal justice or an administrative context, right, that implicates our privacy, that uses information about us in ways that don't click the charter protections, right? So then the question is, what's the legal regime around that? So there's this huge controversy around Clearview AI, right, which is this particular facial recognition system that it appears that a bunch of let's say RCMP and officers and other police forces experimented with in some way without necessarily going through all the appropriate channels, right? So they set up a facial recognition system, right, in Canada, or used it. And we're still trying to figure out what they actually did. But let's just assume, for the sake of argument, that they, connected a camera with Clearview AI on Parliament Hill at some protest, right? And they were able to positively identify all the protesters. Is that a charter? Is that a search that implicates the charter protections? Not sure, not clear, right? So what we're sort of what we need to do as a society is sort of build up a tiered approach, right? So the way that we would usually deal with that kind of privacy question is not so much at the moment of the particular deployment of the camera in the public place, but rather the procurement system, right? Do we procure this? What are the rules around the procurement of the system? What are the background rules of privacy as to how governments use data, right? So I think that's sort of what the law is really grappling with at this moment. Like, we do have some law that governs this that's a little outdated and a little, it's not structurally set up to deal with this new environment, right? And I guess the thing about the new environment, again, it's pervasive data collection and storage and analysis, right? Forever. Our digital traces are basically going to last forever because storage is so cheap that there's no reason to get rid of it unless you mandate that you need to get rid of it, right? So that's where I see a major gap in the law.
Sounds like there'll also be profound implications for our political systems. You could think of Cambridge Analytica as one example, but how might governments or political systems be trying to use the data, do you think?
So the Cambridge Analytica scandal, which I think many people are familiar with, at least by name, right, I think represents a real crisis for democracy. In a democracy, we would think that the way things operate are that voters should choose their elected officials. Cambridge Analytica shows you how candidates for political office can choose their voters, right? And basically what happened, right, is all of that data that Facebook had collected in order to be able to target ads at you for sneakers or hair dryers or whatever, ended up being used to target political advertising, right, at two kinds of people in the United States, right? One was to try to drive up the voter turnout for Trump, right? And the other was to try to suppress the votes of those who were anti-Trump, right? So, at the very existence of that kind of technology raises very profound questions about what does it mean to live in a democracy? What is the nature of democratic debate? How should we conduct elections, right? What does it mean to be an informed elector, right? Uh, in a moment where it's possible to micro-target messages at individuals or very small groups of people, right, and kind of get away with it until much later on, right? So, I mean, there are some regulatory interventions here in Canada to try to deal with that, at least with regard to regulated political entities in Canada. The problem, of course, is that we can pass wonderful laws that, govern how the Liberal Party acts or the Conservative Party or individual Canadian citizen donors, and we can enforce that against people who happen to be within the reach of Canadian law. But then you have the Chinese and the Russians and the Iranians and whoever else who want to wreak havoc on our elections using these global platforms to reach into Canada and interfere, right, with our elections. And there's some anecdotal evidence that, for example, the Chinese may have tried to uh, have some influence operations during the recent Canadian election campaign using TikTok, right, and WeChat, which are both platforms that are based in China, right, where the Chinese government has a lot of visibility. Um, so this is kind of a profound point of vulnerability for the integrity of our democratic processes, and I think it just again raises fundamental questions about what does it mean to have a democratic system of government in this age.
And then when we shift gears and talk about medical information, you could imagine a scenario where perhaps a medical professional could give you information about a test that you received through an app on your phone. I'm guessing that you probably have some thoughts or perhaps even concerns about the use of that type of data.
Yeah, so one of the things when it comes to privacy law is that people kind of posit that there are two big models. There's like a European model of really comprehensive protection that covers everything. There's this American model of very sectoral protection, like we have a law in each section. And folks like to think that Canada's a bit closer to Europe than the US, but I think we're really in between. And I think our approach to medical information shows this, right? So the way that health information is protected in Canada, right, is that, well, it's pretty well protected when you're a patient in the medical system, right? You go to your doctor, you go to a hospital, you go to a physiotherapist, right? And you have some kind of interaction with a medical care provider, a dentist, right? Um, we have a law, for example, in Ontario, the Personal Health Information Protection Act, right, that governs how medical providers can collect and use and disclose your data. And the basic rule is that they can't do anything unless you consent. And there are exceptions. And that's kind of how a lot of privacy law is set up, right? In Canada, you need consent unless there's some kind of exception. The problem is that there's a lot of health data that is outside the healthcare system. So I have an Apple Watch on my wrist. It is silently collecting data about my heartbeat, showing how unhealthy I've become being, in the last 4 months, having been cooped up in my house. So that's health information of a sort, right? But Apple isn't a healthcare provider, right? So arguably, PIPEDA, which is the federal private sector privacy law, writ large, applies to that data rather than the enhanced protections that we have for health information for healthcare providers. But wait, there's more. It gets even more complicated. Like many of you, I have a PC Optimum card that I love because it gives me deals on the stuff that I buy. But okay, consider this. You're the kind of person who buys a lot of potato chips, or you're a kind of person who buys a lot of kale, or you're a kind of person who buys a lot of kale chips, right? The point is that you are what you eat, and that your like grocery shopping information, or Loblaws now owns Shoppers Drug Mart, and the Optimum card is linked up to Shoppers Drug Mart too, right? Your purchases at a drugstore, of over-the-counter medications are very revealing of your health status, right? But yet that is not subject to the same level of protection as what we consider to be, medical information in the healthcare system, right? So we have this kind of differential approach to privacy based on who holds the data, right? And that is at least potentially problematic, right? When it comes to the fact that this information could be used against you, right? It could be used to discriminate against you in many different ways, right? I mean, we just had a case in the Supreme Court just a few days ago upholding the Genetic Non-Discrimination Act, right? The Federal Genetic Non-Discrimination Act, which is a very important case. I mean, it was mostly a federalism case, but the law is very important in establishing that you can't be discriminated against on the basis of your genetic information. Like if your genes show a predisposition to a certain kind of medical condition, that can't be used against you, like for example in the insurance context, right? Well, the question is like what do all of these other kinds of data that are revealing of your health or any other sensitive characteristic, right? Race, religion, sexual orientation, right? How can or can they not be used against you?
I guess if I'm really a hardcore freedom of contract type person, though, I might say, well, you agreed to that, right? There were terms of service. Sometimes even the app will make you swipe all the way to the bottom. And once you've done that, there's a click accept button. Uh, can you walk us through some of the things that we are allegedly agreeing to in these terms of service agreements?
Sure. So, I mean, the thing about these terms of service agreements is all of them are written by very smart lawyers who are seeking to defend the interests of their clients, right? Like all good lawyers do, right? Um, so they are by definition one-sided, right? So they're trying to provide the companies with whom you are signing those agreements with maximum flexibility for the most part, right? So some of the things they include, right, within the confines of what the law permits. But some of the things that they permit, right, for example, and this is relevant to how good is Canadian law. So let's assume that Canadian law is better than the privacy law of the United States, which it generally is. Um, Many of these contracts contain what are called forum selection clauses or arbitration clauses. So if you look at the Facebook or Google terms of service, they'll say, this contract is governed by the laws of California. Any dispute arising under this shall be litigated in the courts of Santa Clara County, California, which is where all the tech companies are based, right? So if you don't like it, and you have a beef that you want to litigate, at least theoretically, you need to fly when you used to be able to fly, across the continent to enforce your legal rights. So that's one kind of problem. But there's also other kinds of issues in terms of what are you agreeing to in terms of the use of the data that they make, how they share that data with third parties, et cetera, et cetera, et cetera. But at the root of all this is um, how meaningful is the consent that you are giving when you click I accept, right? So, take a service like Uber or Lyft, right? Which basically they've destroyed the taxi industry in much of the world, right? So if you need point-to-point transportation, you have no choice but to use Uber or Lyft. So you don't really have a choice, a meaningful choice with regard to the terms of that contract. If you want to uh, participate in a modern social network that connects hundreds of millions of users in order to be able to communicate, you really don't have a choice but to use Facebook or Twitter or Instagram, Instagram being owned by Facebook, right? So again, there's the question of how meaningful is that consent? Google, right? I mean, I guess there is Bing and DuckDuckGo. Can't remember the last time I searched on either of them, right? Again, so that is one of the really hard things. And interestingly, our Supreme Court has kind of been at the forefront of sticking it to big tech in this series of cases over the last few years. So I think it was in 2017 or yeah, I think 2017. There's this very important case, Duez versus Facebook, um, where the Supreme Court said that Facebook's forum selection clause was unenforceable given the particulars of that case. Then just recently, last month, the Supreme Court ruled in Uber and Heller, which was a case about the validity of Uber, so Uber's contract with its drivers. If you're on the driver side of the app, if you have a problem with Uber, not only is the contract governed by the laws of the Netherlands, but if you want to dispute something, you need to go and arbitrate your dispute in Amsterdam. And in order to arbitrate your dispute in Amsterdam, you not only have to fly there or find a Dutch lawyer, you need to pay all of these upfront fees to access the arbitration. Like, I think it's like works out to $15,000. So Heller's an Uber driver in Toronto who had some problems with Uber and wanted to, fight this, and he disputed the validity of this arbitration clause. And the Supreme Court majority struck it down, right? They said it's against public policy, right? Because it basically the barriers to get in the door to arbitration are so high for an Uber driver who on average may make $20,000 a year, right? It would be 75% of their annual income to get through the door. So we're seeing some pushback against all of this. I think, where we need to go is to have more regulation that standardizes what's in and what's out. Oh, the last little tidbit I want to share about this is that despite the interface that you mentioned that, forces you to swipe through 75 pages of microscopic text before you can click I accept. I mean, there's the other problem around meaningful consent is that it's just impossible to read all of that stuff. I mean, studies have been done that shows if the average North American consumer were to sit there and read every one of these contracts and privacy policies that they get in the course of an average year, it would take the equivalent of 78 workdays, right? Like you would spend a quarter of your year just going through that boilerplate, right? So if that's the price to access services that you have no choice to access, it's a price that's too high and that the law has to do something about.
Yeah, so last few questions will just be directed more towards our first year students. So our students are going to be taking a variety of courses, including contracts. They might talk about the Facebook case or the Uber case in that class, but what courses can students look forward to taking in either their second or third year of law school?
Oh, well, we have a ton happening here at the Faculty of Law. I don't think there's a better place in Canada if you're interested in technology law. And frankly, we're one of the top few in the world when it comes to the richness of our tech law offerings. So it all begins with a general introduction to law and technology that's been taught by Katie Salagi for the last few years. So, that's kind of a gateway course for a lot of our students. And then there are so many specialized offerings. I'll be teaching privacy law this fall. My colleague David Fewer teaches regulation of internet communications. Michael Geist runs this incredible course, again, at least when people can travel, which involves an exchange with the University of Haifa in Israel, which is sort of a center of technology law scholarship in Israel. We have strong offerings in copyright law, other areas of IP law, which are really important, competition law. And then I'd like to talk about CIPIC, which is the Canadian Internet Policy and Public Interest Clinic, which I direct. And what a clinic basically is, it's a small public interest law firm inside the Faculty of Law that takes on real cases and provides assistance to real clients or intervenes in real cases before trial courts and appellate courts, of course, across the country. So in your second and third year, you can enroll in CIPIC for credit, right? And it's a great experience because you get practical legal experience. You will work on drafting legal memoranda, on FACTA that we submit before courts, developing policies for clients, right? Doing research sometimes for internal clients in the university. So that's a great experience as well that, I think it's something relatively unique in Canada. We're one of the very, very few in Canada, law schools in Canada that has this kind of program. in the technology area, and we're one of the biggest too, so there's a lot of opportunity. But again, there are a ton of courses. I mean, the other thing about tech law is that, yes, there are tech-specific courses that interrogate the law of technology. Florian Martin Barreto has a course on blockchain, for example. But the general law school courses are super important and super interesting too. And I have a friend who is a leading tech lawyer in the U.S., and he's now in his 60s. But all of his degrees, except for his law degree, are in classics. They're in like Greek and Latin and ancient history, and they remain excellent grounding, though, for a career in technology law, because they sort of give you the discipline of sort of logical reasoning and rhetoric and focus that you need to be an effective lawyer in any field, right? Not to mention that reading ancient Greek can be a bit like parsing technology, right? So students who are interested in this area shouldn't feel that they just have to load their plates with tech law stuff. That some of the other more general courses that we offer, like for example, business organizations, are super important to practicing in this area.
So if I'm a first year student and I'm like, I really want to get involved in law and technology, what should I do? Do you have any advice in the first year program on things that students could do to get their feet wet?
Absolutely. So I think there are three big things that first year students can do. The first is to get involved in the Law and Technology Student Society, which is a great student organization here on virtual campus, I guess, for this year, that organizes a lot of events featuring speakers. And some of the events are more like, again, discussions. Some of them are practical, like tutorials on how do you equip your laptop. So it runs the gamut. I think that a lot of the students who are interested in tech law end up as part of that student society. So I'd encourage folks to sign up for that. The second thing we offer is, and this is through our Center for Law, Technology, and Society, is something called the Technoship Program. And the Technoship Program runs in the winter term, and it offers first-year students basically the opportunity to work one-on-one with a professor, mostly in the Faculty of Law, but also sometimes in other faculties like engineering and social science, so people who have technology law and related research interests. So it's a paid internship. Students get paid. They work for, I think it's about 50 hours over the course of the semester and get paid a modest honorarium, but it's a fabulous experience, right? To sink your teeth into cutting edge legal research on technology law and to form relationships with professors. Then lastly, my clinic, CIPIC, we do accept first year students as volunteers. So you can certainly do that. I myself would encourage people not to do it in their fall semester when the learning curve in law school is the steepest, much as we love the help. But I think it's something to contemplate in the winter semester. Once folks feel that they're grounded and know their way around the place, it's something to consider as well.
And last question, any advice that you would give to law students that are about to embark on this momentous occasion of starting law school?
Yeah, I wanted to share a little bit of a personal story here around perseverance. And when I started law school, I was very excited. I figured that, I'd always sort of had the sense that I wanted to be a lawyer and this would be a perfect fit for me. I got to law school. It was my first week at law school. And I was in class and I had no idea what was going on, right? And I felt that there were other students around me who got it, and I just didn't, right? People were talking about, oh, this is dicta, this is obiter, this is the holding. I was like, what are you talking about? I don't get it. So I actually looked into the refund policy for my law school, thinking that I should just get out when I can, get my money back. But I called a friend who had graduated from law school and was sort of in the early stages of his legal career, and I called him and said, I'm thinking about this. What do you think? And he said, no, don't do it. Right? Like, it is a really steep learning curve at the beginning to figure out how do you read a case, right? How do you parse the statute? Like these are not skills that you acquire in your elementary or secondary or university education, right? There's something that gets inculcated to you in that first semester of law school, and that's really hard. It's like learning a whole new discipline very quickly, right? So I did stick it out, and here I am today. But there's two things I wanted to say about that story. So other than, the advice to stick it out is fine and good enough. But I think what really made the difference for me was having a friend that had been through this experience and who knew me and could offer that advice, having known me, right? And that's a form of privilege that I had. To know this person, right? And he was a friend. He was a couple of years ahead of me at university. I could imagine that a lot of students here do not have that privilege, right? You may not know a lawyer in your social networks, right? You may be a first generation student to go to university in your community, right? I'm very proud of the extremely diverse student community that we have at this university and this faculty in particular, right? So what I would say to you, and this is a especially difficult year for our first year students who are starting remotely, which to me is unimaginable. And I think I speak for my colleagues in saying this, which is that if you are that person who is like me and you're sort of there trying to say, what's going on? I don't get it. Feel free to reach out, right? Like reach out, ask for that help, have those conversations. We are here for you and we care about your success and want this to be the right thing for you, right? So I think that's like a really important aspect of mentorship in this particular era. I mean, it's true in general, but especially now. So I really wanted to share that story, to know that, you're not the first to go through these experiences. You won't be the last, but finding resources and support to help you through it is going to be key.
Well, I'm really glad you stayed in law school so that we could be colleagues. And thank you so much for sharing your infinite wisdom with us today. I'm slightly terrified now of my computer and my phone, which I think is a good place to start. And thanks so much for being on the pod.
My pleasure.
You've been listening to an episode of the Orientation Podcast series from the University of Ottawa Faculty of Law Common Law section. You can subscribe to the Orientation Podcast series on Apple Podcasts, Google Podcasts, Spotify, YouTube with closed captioning, or wherever you are listening to this episode right now. If you are a first-year University of Ottawa Faculty of Law student, you can also find additional sources at the Orientation 2020 Brightspace page. Thank you for listening, and we can't wait to meet you soon. This episode has been produced by Tech Law Fellow June Gleed.